Welcome to Pregnancy Help Podcast. This episode is part of our series on the Dobbs versus Jackson Women's Health Organization case, and we're talking about what happened during the recent oral arguments and what might be coming next. We have Jor-El Godsey, president of Heartbeat International, and Danielle White, our legal counsel, here to give you all of the details. They were actually in D.C. outside of the Supreme Court while the arguments were going on, so I'm sure there's some interesting insight there that they have for us. But before we get started, let me mention our sponsor, PregnancyHelpNews.com. If you'd like to keep up with news on the Dobbs case and other happenings in the pro-life community, go to PregnancyHelpNews.com and subscribe for their weekly updates.
Thanks, Christine. Great to be back with you. Now, a lot of this groundwork that we covered back with Dobbs 101, kind of discussing like why is this case important. We even went over some of the history of abortion law, Danielle, that you kind of helped walk. Had Ellen with us as another attorney in that journey. So if you haven't heard much of that, I encourage you to go back and go through Dobbs 101 first, and then come back to this, because we really want to talk about like what happened that day, like what was the atmosphere like, what was the arguments that were proposed. And so I'm going to get to the arguments in a minute, Danielle, but the atmosphere was really interesting. It was uncharacteristically beautiful day in D.C. It was actually very crisp and cool, but we had an amazing turnout by the pro-life community. There was a lot of sidewalk activity out in front of the Supreme Court, and I think the pro-lifers outnumbered the other side easily 3-1, maybe 4-1 at any given point in time. Of course, there was competing decibels of loudspeakers there was those two tracks running at the same time of the pro-life presenters that were speaking at the foot of the steps of the Supreme Court, and then there was the pro-abortion speakers that were speaking, and it was quite the contrast of messaging amongst the pro-lifers. There was a tremendous sense of hopefulness. Like, it's been 30 years since we've had an opportunity to have this type of discussion at the Supreme Court level that carried so much weight as being really focusing in on Roe, what that could mean. And it all really kind of comes down to the 15-week ban that's being proposed by the state of Mississippi. And that's exactly what was at issue. There's a couple of big issues that the oral arguments focused on, but of course the 15 weeks is below of the previous Casey line of viability, and so that's really why it makes it such a big deal. So Danielle, you listen intently to the oral arguments, and you've listened to them not just once but many times now. And so, like, what did you hear particularly related to the 15-week and viability line of questioning from the justices?
Yeah, so the 15-week ban in Mississippi, it's a lot easier to see where the court is going with that. The argument had unusual amounts of clarity, I thought, in just kind of where the justices were, what they were thinking on the issues, particularly with respect to the Mississippi ban that was at issue. I think it's very safe to say that this court will vote 6-3 on the Mississippi issue, meaning that 6 justices would vote to uphold the law, the Mississippi law, and then 3 justices will dissent and say that they would have struck down the law as unconstitutional. And as I'm listening to lots of different legal analysis, and a lot of the analysts that I'm listening to and people that I respect, I think that are following this really closely and have been watching the court for a long time on this issue, there's broad agreement that the court is going to uphold the Mississippi law. The question remains not, is this Mississippi law going to stand, but rather, how will the court uphold the law, and what will be the reasoning, and how will that impact abortion jurisprudence going forward, or abortion case law going forward?
Because the issue is of course Casey and Roe, which are kind of the standing arguments or laws and rulings, I should say, that SCOTUS has maintained as a deflector of any other laws, right? They've used Casey and Roe in varying ways to say, no, this is a constitutional right that is to abortion, and therefore it strikes down laws that try to erode that right. But now, in this day and age, the Mississippi law is basically challenging it head on. Is that correct?
Yeah, that's exactly right. And more to the point, the case law leading up to this point said that pre-viability, and this is where we get into the viability question, pre-viability, a state could not prohibit abortion, that prohibiting an abortion prior to the time of viability was unconstitutional. And Mississippi went ahead and prohibited abortion prior to viability anyway. And that's how that viability question finds its way to the court for this argument.
Got it. So then, as the argument unfolded, there was this really interesting struggle between what the courts have previously decided and where they would land with this one, because we heard this precept in law, which is stare decisis, right? Which let the decision stand, right? That's the age-old precedent construct, right? Well, we have to follow precedent, and of course the argument against it is you can't follow precedent if the precedent was bad. We saw that the courts have had to change their mind and reverse precedents from the past in order to make things right. And that is the other thing that's at the core of this. If the viability rule is not a good line of demarcation for the law to observe, which is what was partly being argued, right? That this is an untenable situation, and most of the justices actually affirmed that it was somewhat of an untenable area to hold, because it's not a statement of fact, it's a statement of technology, right? We know it's been changing over time. So that puts then where else do we draw the line, which now takes us back to Roe really being in consideration. It's not a question of 15 weeks or 16 or 14 or 12 or whatever the number is, because that's as equally arbitrary. It's a question of, should we even be having this considered as a right in our Constitution? And that's where the argument really discussed the role of the Supreme Court relative to deciding what are rights that we are to uphold.
Right. I think we saw Justice Roberts grappling with that in a most pronounced fashion. I think it may be helpful to kind of place ourselves in where we think the justices might have been prior to oral argument. Where might they have been inclined to vote? And so, I think that everybody knows it's very safe to say that Justice Thomas would vote to overturn Roe. He's said that in the past. I think it's very safe to say that Justice Alito would also vote to overturn Roe. I think Justice Gorsuch is a fairly safe vote to overturn Roe. Then, of course, you have the three more liberal justices on the other side, Justice Sotomayor, Justice Kagan, and Justice Breyer. So really, for this argument, all eyes were on three justices, and those ones were Justice Kavanaugh, Justice Barrett, both of those are Trump appointees, and then Justice Roberts, who is the Chief Justice. And just some of Justice Roberts' questioning was very interesting, as he was trying to figure out, how does viability play into this, especially because of stare decisis? They're all wrapped up together. And as much as the court was kind of dividing them out, or maybe trying to divide them out, if the court's going to get rid of the viability line, it almost can't uphold stare decisis in a sense. Meaning, if the court's going to follow its own precedent, it looks silly for the court to say, like, well, we have to keep Roe because we have to keep our precedent, we have to follow precedent, but also the viability line is gone. But wait a second, the viability line would be entitled to precedential weight as well. So that's kind of the conundrum that they're in. And as far as trying to find some sort of a middle ground that doesn't overturn Roe but still allows this law to stand, if the court were to allow the Mississippi law to stand, it seems to suggest that they would have to overturn Roe versus Wade, Planned Parenthood versus Casey. And so Chief Justice Roberts, at one point in the argument, saying that perhaps the viability line is not entitled to like this precedent, the weight of precedent, because it's just dicta, which is a legal term for when the court is just kind of talking in their opinions, but it's not the central holding. It's not the main point of what the court was getting at. It's just dicta. Now, with dicta, the lower courts don't have to follow dicta, and it doesn't have precedent. So you could see Justice Roberts trying to kind of wriggle around, like, well, maybe that viability line wasn't actually our holding. It was just dicta. And the advocates on both sides really weren't letting him go there. So the attorneys, both for the pro-life side and the pro-choice side, we're really sticking to, look, you either have to overturn Roe or you have to strike down this Mississippi law.
Because the dicta is really statements that were made apart from the ruling or conversation upon which the ruling rested on, which I think was called out in the arguments that didn't this go back to the original Roe conversation and how arbitrary in that instance the trimester system was, or viability was also arbitrary. It was the original writers of Roe that made this. Didn't that come out during this conversation?
It did, and maybe we'll go to that portion of the argument.
We pointed out as an example, Your Honor, of where Roe and Casey improperly preclude states from taking account for these things, and they should be able to be concerned about a fact of an unborn life being poked and then recoiling in the way one of us would recoil.
General, I know what it said about viability in Roe, but was viability an issue in the case? I know it wasn't briefed or argued.
It was not an issue certainly the way it is an issue here, Your Honor. I think it was, to the extent that the court had to reaffirm Roe. The way to read that as something other than dicta would be to understand.
I'm sorry. I don't know what that said. Was it an issue in Roe?
Oh, in Roe?
Yeah.
I'm sorry, Your Honor. My understanding is no. I mean, the law there was didn't have a viability tag. That was inserted by.
In fact, if I remember correctly, and it's an unfortunate source, but it's there. In his papers, Justice Blackmun said that the viability line was dicta, and presumably he had some insight on the question.
I think, and I'd add, Your Honor, Justice Blackmun, and I think as well his papers pointed out the arbitrary nature of it and the line drawing problems in there too.
And then in Casey said that was the core principle or the central principle in Roe, viability. It said that after tossing out the trimester formula, which many people thought was the core principle. But was viability at issue in Casey?
I don't think it was squarely at issue, Your Honor. Again, it's a little hard not to take the court at its word when it emphasized that viability is the central part of Roe's holding, and saying that it is reaffirming that. So we kind of take that as it stands, but the court has not. It did not face a law like this, certainly, Mr. Chief Justice.
So there you can kind of see what Justice Roberts, I think, might have been exploring, which was, is there a way that we can let this Mississippi law stand while also upholding Roe and Casey? And I think what he was kind of proposing is, hey, we'll just say that the viability line was just dicta, and the court, they weren't really, it wasn't the central part of the holding in Planned Parenthood versus Casey to say, that this viability line exists and it kind of dictates how these laws will be analyzed. I think that would be surprising to pretty much anybody who litigates abortion law. It'd be certainly very surprising to the lower courts. I mean, the whole reason we're at the Supreme Court right now is because the Fifth Circuit struck down this law and said that this law is unconstitutional precisely because of the viability rule. And so I think as much as Chief Justice Roberts may want to be trying to finagle a way to uphold precedent and also still allow this law to stand, I think that's going to be a difficult thing for him to do. And you see that come out a little bit later on in the argument, particularly when Justice Gorsuch asks some questions of the other side.
May I ask you a question about stare decisis, Counsel? Your colleagues on the other side have emphasized that Casey rejected Roe's trimester framework and replaced it with an undue burden standard. They argue that the undue burden standard was not well known to the law before that. And then they argue that the undue burden standard has evolved over time, too, in ways that the court has found difficult to agree upon. In Hellerstedt, for example, they point out in their briefs that the court seemed to suggest that a court should consider both the benefits and the burdens associated with the proposed restriction. In June Medical, more recently, the court splintered on that same question, whether benefits could be considered or only burdens. And so the argument goes that this has proved to be, putting aside all the other obviously difficult questions in the case, that the standard itself has proved difficult to administer and that is relevant to the stare decisis analysis. And I just wanted to give you an opportunity to respond.
Yes, Your Honor. The first point I'd like to make is the undue burden test is not at issue in this case. That is the test that applies to regulations, not prohibitions, and the state has conceded that this is a prohibition. In fact, that's the title of this law, is an act to prohibit abortion after 15 weeks. And the only thing that's at issue in this case is the viability line, and the viability line has been enduringly workable. The lower federal courts have applied it consistently and uniformly for 50 years, and the Fifth Circuit here below had no difficulty striking down this law unanimously 3-0. So it's been an exceedingly workable standard. And if I may return to your question, Mr. Chief Justice, a reasonable possibility standard would not be workable. It would ultimately boil down to an argument that states can prohibit a category of women from exercising a constitutional right merely because of the number of people in the category. And that's just not how constitutional rights work. A state would never say that it could ban religious services on a Wednesday evening, for example, simply because most people could attend religious services on another night of the week.
So I actually just wanted to that's helpful, I think. I just want to make sure I understand what you're telling me, counsel, that if the court were to, in this case, step past viability and apply undue burden, the undue burden test to regulations prior to viability, you would agree with the other side, I think, that that's not a workable standard. Is that a fair understanding of what you're telling the court?
No, Your Honor. I believe
think that would be workable?
I believe that, if I may clarify, I believe the undue burden test has been workable for regulations.
I understand that. If it were to apply, if the court were to, and I thought this is what you were saying in response to the Chief Justice, but maybe I'm mistaken. Please correct me if I am. But what is your argument against applying the undue burden standard prior to viability?
If the undue burden standard, as this court laid out in Casey, which includes the viability line, is applied.
I'm asking. I know we're fighting the hypothetical here, counsel. All right, accept the hypothetical. Hypothetically, the court were to extend the undue burden standard to regulations prior to viability. Would that be workable, or would that not be workable in your view?
Without viability, it would not be workable, Your Honor, because it would ultimately, again, always come down to a claim that states can bar a certain category of people from exercising this right simply because of the number of people in the category. And that's not a workable standard, and it's not a constitutional.
I appreciate that clarification. Thank you.
So you can see Justice Gorsuch kind of swinging around to that idea of viability and could the court get rid of the viability line and leave the rest of Roe and Casey intact? And then you hear the pro-abortion attorney there, Julie Winkleman, who's arguing for the Center for Reproductive Rights. You hear her saying, "No, Your Honor, we couldn't do that. That wouldn't be workable." And so she's really setting up there's kind of a no middle ground sort of argument here. And I was thinking about that because it seems like a strange thing for her to do, to set up you either overturn Roe or strike down the Mississippi law. But the reality is that her job is to advocate for her client, which is the abortion clinic there in Mississippi. And so it probably would have been better for her strategically to say, you could get rid of the viability line and just allow undue burden to carry the day. But that wouldn't have protected the interests of the abortion facility there in Mississippi. And she's trying to get that law struck down. So what's interesting to me about that is that in arguing to strike down the Mississippi law, she may be positioning the court to overturn Roe, which is just sort of wild to me.
So you say positioning, meaning in one way she's trying to put them on the horns of the dilemma, right? She's trying to basically say, oh no, there's none of this fuzzy middle ground. You either have to stay where we are or you're going to have to go radical. It's kind of what she's implying.
Yes.
When of course it's her position, that's what's radical and remains radical. But part of that is kind of captured in really Kavanaugh's line of discussion, because he he calls out, hey, by the way, this august body has reversed itself a number of times. And he doesn't list just one or two. He lists 8 different times where the court has reversed itself on its own precedent, really. And he goes right after stare decisis. But to me, Danielle, what he does is he brings out these 2 words, which I thought, wow, that's really amazing. He seems to advocate for the position of the court to be scrupulously neutral.
Mm-hmm.
And that goes to the heart of really what the court is called to do versus what the legislature is called to do, which goes at the very heart of Roe, because Roe was 7 unelected justices determining and reading into the Constitution this right that they produce basically out of thin air that protects abortion in our land. So this is essentially the justices acting as super legislators, but not elected ones, which is kind of the argument for against Roe. Why to overturn it? Because this is such a controversial issue that the courts weighing in and declaring it a right, therefore protecting it from any legislators looking at it, is a problem and maintains the controversy. And Kavanaugh steps in and says, well, shouldn't we be scrupulously neutral on this?
Mm-hmm. Yeah, and I've got the clip for that.
I think the other side would say that the core problem here is that the court has been forced by the position you're taking and by the cases to pick sides on the most contentious social debate in American life, and to do so in a situation where they say that the Constitution is neutral on the question of abortion, the text and history, that the Constitution's neither pro-life nor pro-choice on the question of abortion, and they would say, therefore, it should be left to the people, to the states, or to Congress. And I think they also then continue, because the Constitution is neutral, that this court should be scrupulously neutral on the question of abortion, neither pro-choice nor pro-life. But because they say the Constitution doesn't give us the authority, we should leave it to the states, and we should be scrupulously neutral on the question. And that they are saying here, I think, that we should return to a position of neutrality on that contentious social issue rather than continuing to pick sides on that issue.
Yeah, so Justice Kavanaugh there kind of framing it as, here's what the other side would say. But one has to wonder if Justice Kavanaugh might also say that himself. So if you're keeping score at home, we've got, I think, an easy 6-3 for leaving the Mississippi law in place. So that leaves the question of how will the court do it? Will they find some sort of strange or invent some sort of new standard or test? Will they just leave us with this undue burden standard that has been very, very difficult for the lower courts to administer, and will lead to a ton more litigation as we all try and grapple with this undue burden standard as it's applied to a pre-viability law? Or will the court reverse Roe? And there are a lot of analysts that are saying Roe's on the ropes. And so if you're keeping score on the Roe count, you've got your 3 liberal justices who would not vote to overturn Roe. You've got 3 that I think are fairly safe reverse Roe votes. But man, you listen to Justice Kavanaugh in that oral argument, and I would say he's a pretty safe 4th vote. Justice Barrett had some moments where it seemed like she was questioning stare decisis, which is an idea we haven't gotten into yet in this podcast, but we talked at length about stare decisis in the Dobbs 101 podcast. But there were definitely some questions that indicated that Justice Barrett was just not convinced that Roe is some sort of super precedent that the court has to adhere to simply because it's been decided in the past. So, I think that there may very well be 5 to overturn Roe. And, it's dangerous to make a prediction just based on oral argument, and here's why. Oral argument was on Wednesday. On Friday, the very next Friday after the oral argument, the court gathered together all of the justices in one room and they gave a preliminary vote. Nobody knows besides them and perhaps their clerks where that vote landed. But once that vote was given, then the drafting process begins. And a lot of this is going to have to shake out in drafting. And there's lore that Justice Kennedy, back when Planned Parenthood versus Casey was being decided, initially voted to overturn Roe, and then in the drafting process changed his vote. So our work here isn't done as we try to continue to encourage the court to do the right thing and to overturn Roe, give this issue back to the people. That's why you'll still see lots of analysis and pieces kind of grappling with some of the issues that were raised in oral argument, maybe trying to give different perspectives and ideas and encourage the court. And it's also a good call to prayer that these justices are going to be grappling with these issues for the next several months. We would expect an opinion sometime in June, so 6 months or so. And a lot can change between oral argument and when the actual opinion is issued.
And one of the reasons that is because voting on something yes or no is not the same as having to draft the actual reasoning behind that vote and what will sustain that vote. And that's part of the adventure. I know, listening to some of the lawyers who were involved with with arguing the case, that's really what they were kind of saying is like, hey, you can imagine some kind of line exists between the viability line going away and not overturning Roe, but finding it and writing it is a different story altogether. And I thought that was fascinating, right? Like having to kind of then sit down and rationalize the exact place where that line ought to be is no small task. We find it hard to envision. Not that courts haven't been able to kind of weave their way into that, in varying ways and with varying justifications, but that still remains to be seen whether or not that will happen.
Yeah, that's absolutely right. It's gonna be a process as the court grapples with that line. And I think if you have 5 justices who are willing to overturn Roe, it would be curious to see maybe Justice Roberts would go with them just to, if Roe's going down, maybe he'd want that to be a little bit more of a cohesive court that's issuing such a momentous decision. So we'll see.
We will. And I was reading today, actually, an article that talked about, he's already really proposed all of the elements. He's supported all of the elements in other rulings that would need to come together in order to overturn Roe, that he already has that and proposed those varying elements in different rulings for different reasons, but the rationale is all there in his own words to overrule or to overrule Roe, to return the issue back to the states and undo that right in the Constitution that Roe found originally and Casey upheld. So it's going to be very interesting, Danielle, and we'll probably be reading all the tea leaves between now and then. But and really, what we have to wait for, barring anything unusual, is that we will see the ruling late June, right, or early July, possibly.
Yeah, that's correct? Right. Yep, most likely.
So they'll toss it out the front door of the Supreme Court and then run out the back door, right? That's kind of in my mind. That's what I always envision happening, which comes to us really from the tradition of them assembling and then returning to their homes. But it's not quite that way now. But it really is how that works, and so there will be certainly a decision. Well, short of them just simply saying no, thank you. We've decided to let the Fifth Court ruling stand. Like, that's a possibility, although not doesn't seem to be a strong one. We've seen rulings, and then we've seen concurring rulings, and then we've seen, of course, dissent, and then sometimes multiple dissents, right, from different positions. So there really could be a tapestry of a response that we see either arising from all 3 groups in different ways, all the three or any one of them, right?
Mm-hmm.
I can only imagine. Would be curious to see Thomas, right, as if he is going to write something separate, because he's probably been the most vocal on his opposition from the current justices, most vocal in opposition to Roe and to Casey, and we look forward to anything that he would write on this. Hopefully, it's going to be in concurrence, or maybe he would write that ruling. Who knows? But we'll see, and we'll be. This is something, as you said, is a great time to be praying for. My contention. People ask me, well, how should I pray? It's like, well, you know what? It's never wrong to pray for righteousness, right? That righteousness would prevail. We pray for our justices to have that kind of clarity, even for those that have constantly stood on the other side of this issue. We would certainly pray for it for them to have a change of heart. It would be an amazing statement if they would recognize that if they would read the tea leaves of this. I think separately, almost all of the justices have indicated some. I mean, RBG, Ruth Bader Ginsburg, famously argued or suggested that Roe was wrongly decided, and yet she upheld it whenever she had a chance to do that in rulings, or voting in favor of rulings for that kind of right. So we'll see what they do. It gives us something to do, as well as to continually wonder, like, what's going to happen next, and what will that mean? Like, what will any of this mean for the pregnancy help movement? That's going to be an adventure that we're discussing in other podcasts, but it's going to have its footing, and we won't really know what that means until we see the wording that comes out in the rulings. But that gives us an opportunity to pray and to continue to pray for righteousness, and then be ready to act righteously.
For more on the Dobbs case, go to heartbeatservices.org/Dobbs for links, articles, webinars, and we just have a wealth of information on there that we continue to add to. Also, make sure you subscribe to our podcast so that you never miss an episode. Have a great rest of your day, and thanks for listening to this episode of the Pregnancy Help Podcast.